All right, let's get right into it. Today, we're unpacking a uniquely frustrating and honestly pretty fragrant legal battle between a homeowner and their homeowners association. The case is Dennis Tingey versus the Verde Santa Fe Masters Association. I absolutely love digging into cases like this because they perfectly illustrate how a completely valid real-world grievance can just totally misfire if it collides with the strict mechanics of contract law. So get ready because we are going to break down the anatomy of this legal dispute step by step, using the actual court documents to see exactly where things went wrong. Picture this. You open your windows for a nice, fresh morning breeze, and bam, you are immediately hit with the overpowering, undeniable smell of raw sewage wafting right over from the golf course next door. Naturally, you'd be furious, right? You'd want someone to fix it like yesterday. But here's the visceral, real-world question that kicked off this entire legal showdown. Can you actually sue your HOA to fix it? Having a problem is one thing, but figuring out legally who is forced to solve that problem is a completely different ballgame. Okay, let's dive into this. The petitioner here is a homeowner named Dennis Tingey. He lived in a community right next to the Agave Highland Golf Course. And according to his legal petition, living there was turning into an absolute nightmare. He documented this wild, highly tangible list of grievances. We're talking rampant weeds, brush, and actual tumbleweeds blowing around. He cited an, and I quote, excessive skunk population. He noted a complete lack of policy regarding golf course trespassers just wandering around. And then there are the real kickers. Raw sewage smells coming straight from the golf course's irrigation system and wind-carried irrigation overspray from the tee boxes constantly hitting the residential area. I mean, these are serious, everyday quality of life issues. So Tingey took action and filed a formal petition. Section 2, the legal venue, establishing the battlefield. So when you have a grievance like this involving a claned community in Arizona, you don't just march down to the standard county courthouse. You go to a very specific spot, the Arizona Office of Administrative Hearings. Now, before we look at the arguments, we really have to define the legal boundaries of this specific room. Under Arizona statute, specifically ARS Section 32-2199.01, this office has a super narrow jurisdiction. They are legally authorized to hear disputes specifically between property owners and planned community associations, and those disputes must be concerning violations of community documents or community statutes. That's it. The judge in this room can only officiate a match played strictly between the homeowner and the HOA. Keep that tucked in the back of your mind because it is the absolute linchpin of this entire case. Because right out of the gate, we hit a massive structural roadblock. The Agave Highland Golf Course, the actual source of the tumbleweeds, the skunks, and that lovely sewage smell, is completely independent. It is absolutely not owned, and it is not operated by the Verde Santa Fe Masters Association. This is the immediate, glaring problem with the homeowner's lawsuit. He was essentially suing his HOA for a nuisance happening on a property the HOA didn't even own. Which brings us to Section 3, the homeowner's argument, creative legal maneuvering. So, if the HOA doesn't own the golf course, how on earth do you justify suing them? Well, the homeowner and his legal counsel got really creative. Basically, they argued the HOA was just failing to be a good advocate. I want to read this exact quote directly from the petitioner's response to the court. Petitioner's case is simply one where it is asking this court to find breach because the association refuses to even try to persuade the golf course to manage its property better. See what they did there? The homeowner totally admitted the HOA didn't own the course, but he argued they were legally obligated by their own community rules to at least try to fix the problem through, persuasion and pressure. And what exactly did this persuasion look like? The homeowner gave the HOA a pretty extensive to-do list. He demanded they enforce any existing CC&Rs against the golf course. He wanted them to set up official owner complaint committees to amplify their voices. He even suggested the HOA should withhold support or services from the golf course until they cleaned up their act. Plus, devise specific communication policies or just physically step in and help abate the nuisance themselves. He was arguing that the HOA had to exhaust every single one of these options to do their job as community leaders. Section 4, reading the fine print. CC&R Article 12, Section 12.4. Now, what's really interesting about this is that the homeowner didn't just pull these demands out of thin air. He based his whole argument on one specific clause in the community's governing documents, Article 12, Section 12.4, titled Jurisdiction and Cooperation. Let's break this clause down, starting with the very first sentence. It reads, "It is declarant's intention that the association and the owner of the golf course shall cooperate to the maximum extent possible in the operation of the properties and the golf course." This single sentence was the absolute bedrock of the homeowner's case. He looked at the words, cooperate to the maximum extent possible, and interpreted that as a hard legal mandate for the HOA to go to war with the golf course on his behalf. But Administrative Law Judge Sandra J. Vanella, she didn't quite see it that way. When we look at her legal interpretation, she pointed out that this sentence just expresses an intent to cooperate. It's basically a pleasantry. It's just stating that these two neighboring entities should try to play nice and get along. However, as the judge noted, this sentence grants the HOA zero actual authority over the golf course. It absolutely does not empower the HOA to micromanage the golf course's affairs or force them to fix their irrigation system. And guys, this brilliantly illustrates why you always have to read to the very end of the paragraph in any legal contract. Let's look at sentence 2 of that exact same clause. I like to call this the smoking gun of the case. Ready? The association shall have no power to promulgate rules and regulations affecting activities or use of the golf course except as specifically provided in the golf course declaration. Boom! That sentence right there is a total case killer. It explicitly and entirely strips the HOA of any jurisdiction over the golf course whatsoever. So when we line up the petitioner's expectations right next to the HOA's actual authority, the gap is just massive. The homeowner expected the HOA to withhold services, build official committees, and effectively acts like a police force for the golf course. But the governing documents, the literal rules the homeowner used to justify the lawsuit, state in plain, unmistakable English that the HOA has no power to affect the activities or use of the golf course. You simply cannot sue an entity for failing to exercise power that it legally, factually does not possess. Section 5. The final verdict. Anatomy of a dismissal. We've looked at the gross complaints, the clever legal arguments, and the legal fine print. Now let's break down exactly how Judge Vanella shut this case down on July 21st, 2021. It's an airtight, step-by-step logic puzzle that completely dismantles the petition. Step 1. The HOA does not own or operate the golf course. Step 2. The community CC&Rs explicitly strip the HOA of any power or authority to regulate the golf course. Step 3. Because the HOA has no power, the tribunal legally does not have the authority to order the HOA to do any of the homeowner's suggested remedies. The court can't force the HOA to act outside of its jurisdiction, and therefore, Step 4, the case must be dismissed. The judge made it a point to be really clear about who is actually to blame here. The true responsible party for the weeds, the excessive skunks, the random trespassers, and that horrible raw sewage smell is the Agave Highland Golf Course itself. But remember our very first point about the legal battlefield? The Office of Administrative Hearings only handles disputes between owners and HOAs. They have absolutely zero jurisdiction over an independent golf course. The homeowner had a 100% valid, terrible grievance, but he was suing the wrong defendant in the wrong courtroom. So, what does this all mean? Is the homeowner just completely out of luck, doomed to live with tumbleweeds and sewage forever? Well, the judge actually left us with a pretty provocative thought in her final notes. She wrote, "This is not to say that petitioner may not have the right to seek resolution of this matter in another venue." So, the grievance itself wasn't thrown out as fake or invalid. It was literally just in the wrong arena. Could the homeowner regroup and file a direct nuisance lawsuit against the golf course itself in a standard civil court? Absolutely. It is a very real possibility, and it perfectly highlights why understanding legal jurisdiction is just as crucial as having the facts on your side. Thanks for joining me for this explainer. Keep learning, stay curious, and hey, always read the fine print.